And the High Court in Pretoria has ruled that healthcare professionals don't require a certificate of need. Now, this means they can start their own practices without it. Of course, there will be advantages and some disadvantages as well. Let's unpack these with the Director for the Rural Health Advocacy Program, Russell Rensburg. Thank you very much for joining us this morning. Maybe just furnish us with the details of what exactly a certificate of need is before we get into the advantages and disadvantages of medical practitioners being able to set up shop without it.
Look, I think the certificate of need really comes out of the notion that healthcare, healthcare is actually quite limited. The capacity to deliver healthcare services is scarce, and in a country like ours with significant healthcare need, we have to balance out the needs of the population in need of care with the needs of the health professionals. So the certificate of need seeks then to ensure that healthcare services are equitably distributed amongst the country, to make sure that all populations are able to access healthcare, to ensure that there's no perverse incentives in a sense to create more fee-generating healthcare practices and concentrating those practices in areas where they can get more gain, often to the detriment to others. And I think all of these are done under the context of Section 27 of the Constitution that guarantees everyone access to healthcare services. And it obligates the state to put in place all the legislative requirements to ensure that people can access those services. And you must remember, we can't deliver healthcare services without healthcare workers. And currently we have a significant shortage of doctors, nurses, both locally and globally. And if this judgment is upheld in the Constitutional Court, it could have significant impacts on where healthcare services will be available. Because like I said, if you don't have healthcare workers, you don't have a hospital. Thank you. Over.
Yeah, I mean, it is like a huge advantage, as you've just mentioned, in that there will be the provision of healthcare services in vast areas across the country if it is upheld. But how do we then ensure oversight in this regard? You've mentioned that the certificate of need makes sure that certain rules and regulations are adhered to and people are not taken advantage of by healthcare professionals, or some of them anyway. So in this instance, how do we then ensure oversight?
Look, I think this is a very good question. Firstly, I think that the certificate of need, as it is at the moment, hasn't been enacted really or promulgated for the last 10 years. So on that note, I was curious as to why they went and did the court application now for something that's not in place. Two, I think it will have a negative impact on how people access healthcare services. And I think the regulation component is an important component, and it's not really ventilated in the application, or do we have a proper understanding? Currently, healthcare workers are all governed by their professional councils in terms of their professional practice. But when you look at this application and the number of rights that they feel are infringed by the certificate of need, like the freedom of movement, the freedom to practice their own profession, the right to property, and so forth and etc., I think inferred from that, the unintended consequences could be that there's very little or no regulation as to how we can regulate where healthcare facilities are available. And like I said, that has a negative impact on 80% of the country, or 80% of the country's districts, where the healthcare services are primarily delivered by the state. So if we can't, like one of the measures that we have at the moment is, for instance, like community service for newly qualified doctors. And the intent of that regulation is to get more doctors and healthcare professionals to be able to serve in rural practices. If this regulation is upheld, or this court order is upheld, those healthcare professionals can refuse, in theory, to practice in rural communities, depriving those rural citizens of their healthcare. So I think the important consideration for me here is, while everybody is afforded rights, we also have to mitigate that there is some kind of equality and people have equal enjoyment of rights. And we have to see how those two balance out. At the moment, I don't think that these regulations effectively protect the people or the patients who are most in need of healthcare services, and really prioritizes the needs of the health industry rather than those of the patients.
Yeah, and in my reading, that exactly comes through in that many have said that it's got a sense of unconstitutionality attached to it. And I suppose at the end of the day, the ideal goal here is to ensure that every single person in South Africa gets access to quality and affordable healthcare within their communities, because one of the things that we are finding is that people travel for vast amount of time just to access basic healthcare. So, I mean, conversations of this nature put this into the spotlight and highlight the fact that we need to see some kind of change. And I wonder if a ruling around this legislation is moving towards that direction.
As it stands, I don't think it does that, right? But thankfully, the rulings of this nature must go to the Constitutional Court to check the extent to which it impacts the rights of all people. We saw, for instance, I'll give you an example now, if we leave it to the market to set up things. When we entered into COVID, we didn't have a unified health system response. We had two parallel responses. We had a public sector response and we had a private sector response. We were unable to come to an agreement as a country for a universal access to healthcare during a pandemic or universal criteria for admissions. So what happened was we had 46% of all admissions during COVID happened in the private sector rather than in the public sector, which covers 80% of the population. So only 56% of admissions were in the public sector. So many people were deprived from care because they couldn't access care. The second thing is like with testing, more than 60% of all the tests were done in the private sector. And all of those obviously commanded a fee. We had no regulations on the fee until very late in the pandemic. And people were paying anything from 750 Rand to 1,000 Rand to access the test. And all the capacity was concentrated in a sector where obviously there was a profit and there was a need motive. So the issues of demand and supply came into play. So when, let's say, for instance, this act or this ruling is upheld, there isn't, healthcare or capacity generally follows the funding. We already see it now where in areas with high medical scheme coverage, practitioners operating in those areas can actually generate a higher fee. Whereas in areas with lower coverage, like in our former townships and the like, where there's very little medical scheme coverage, practitioners sometimes even have to charge half the fee than what they do in urban areas. So if not well overseen, you could have this potential that you have a concentration of services where there is a bigger capacity to pay, and then a regression of access to services in areas where there isn't that kind of funding. And I think for me, that's unequal.
Yep.
So the Constitutional Court has to reflect on how we can better ensure equitable access to healthcare without disadvantaging people who are most in need. Thank you. Over.
And thank you very much for your time this morning. That is Mr. Russell Rensburg there talking to us about that holding of a ruling in a high court in Pretoria about the certificate of need, and that it is no longer necessary to need one to open up practice, but also the threats that it poses to the access to healthcare to many of those who may be in rural areas where healthcare doesn't come easy.